Well, here we are. Hello, Elevation Nation. Welcome back. This is the Elevated Podcast. I am your host, Lisa. I am so glad that you're here. I graduated with a master's in legal studies from UCLA Law, specializing in technology law. I am stoked. I feel like I just was on this podcast talking about how it was going to go do this program and go to law school. And that was like 10 months ago. I feel like that just happened. I feel like we were just talking about that. And here I am 10 months later. Yeah, 10 months later, with a degree. And it's been a crazy ride. I don't even have words for it yet. I also turned 29, which was really exciting. There have been a lot of updates going on. And so, with all of this time that I've had in the last 6 days, I decided that I was going to bring back the podcast, obviously, in a really like bigger and better way. I had this whole plan. I was brainstorming yesterday. I had a plan. But we all know what happens when you have a plan. It doesn't happen that way at all. I was going to like wait until, certain things happened before I got on the podcast, I wanted to wait and have a whole plan in place. But the Supreme Court waited for no one, including me. And this morning, they issued their ruling about Gonzalez v. Google, which is the case that I've been talking about on here, which is the case I wrote my capstone surrounding. And I was like, I have to get on and talk about it right now. I can't waste any time. We got to talk about this now today. So, a simple 5 hours later, I've read the outcome. I've thought about it, and I just wanted to get on here as soon as possible and talk about it. So in this episode today, first of all, welcome back. I know I already said that, but welcome back to my people, my Elevation Nation. I've missed you. We have a lot to talk about, and I am saving the where I am in my life, what's next, how do I feel, what's going on, how do I feel about going back to school. I'm going to save that all for a separate episode. This episode is going to be sharing my master's capstone with you all about Section 230, about the censorship of sex workers, and Gonzalez v. Google, which just they issued their ruling today. And I've been really building up this whole ass capstone on my social media. So this is the time. This is our time to do it. If you're listening to this on the podcast, just know that I'm going to release a YouTube version of it so you can see the visuals. But if you're more of a podcast girly or guy, that's totally fine. You're going to get just as much out of it. I wanted to say that because if you need the visuals, I'm not skimping out on you. But I wanted to present this capstone in a more casual way because you are the Elevation Nation. You guys are my friends, okay? I'm going to give you the behind the scenes lowdown of this capstone, okay? I presented this twice, and this is my third time presenting it. I am not sick of it yet. The first time was just to my capstone professor, but then I got the first place in my class and entered into a capstone competition where I presented it again in front of some judges, and that was really exciting. So I'm going to present this again in a much more casual way, but I am going to kind of show you how I presented it as well. And I want to give you the backstory of how we landed on this topic because it took some time. It took a couple of weeks to kind of really land on the core of what I wanted to talk about. When I was first coming up with my topic, I was trying to tread around the topic that I chose. I was choosing like sex education, sexual health, sex art. I was trying to tread around things that I think would be more palatable in an academic setting. And my capstone professor said, God bless her, she said, you're talking about so many different groups of people. Which one do you really want to talk about? And I said, well, the inspiration came from talking about sex workers, porn stars in particular. She said, then write about that. And I was like, but like, is it too dicey? She said, it's UCLA. Come on. You're in Los Angeles. Who cares? I was like, you're right. So that's how we landed on sex workers being the group that I was going to talk about. I'm so grateful she pushed me into that because, like, that's what I really wanted to talk about. And it was just so fun to, like, in an academic setting, research these topics that I've been talking so much about and really get like the legal and factual background of these topics. So I am going to present this capstone with you all, and I would love to hear your thoughts once we're done with this. So be ready to think your own thoughts about this. My way of thinking of this, there's no one way to think about this. It is so complex. It is so, like, there is no one answer to the issues that I bring up. And so I want you to have your own opinions about this. So let's get into it. I feel like I set this up quite enough. So this is how I present it. I say, hello, everyone. I'm Lisa Battaglia. I'm an MLS student. Now I'm a graduate here at UCLA. And it is a privilege today to be talking to you about a topic that I'm very passionate about. And I hope by the end of this, you're at least a little interested, if not also passionate about it as well. Today, we're going to be talking about how the Supreme Court could eliminate online sex work with one decision. And that decision came out today. So we're going to be talking about what the actual decision was and how it's actually going to affect free speech in Section 230 on the internet. So first, I want to start off by telling you about Ashley Matthews. She's a 31-year-old wife and mother. She's a clothing line owner and sex positive activist. She is better known as Riley Reid, one of the most famous porn performers in the world. And although she's left the mainstream industry, she still faces backlash, censorship, and scrutiny for her past. And after building so many Instagrams and millions of followers and creating a living through her social media, Instagram censored over a dozen of her accounts, not necessarily because she violated community guidelines, but because of her job title, commercial sex worker. So here is Riley Reid talking about that.
It sucks. I mean, you've been through it a million times, so I feel like you're a little less phased than me, although it's super annoying.
How many actually though? Like, if you had like 3 or 4 Instagrams that were over 1 million?
No, I probably had like 12.
12 that were over 1 million?
I had maybe like 5 that were over a million.
But
like, you kept making new pages and they kept getting deleted like the day you made them. I remember that. Yeah, sometimes they would get deleted like same day and stuff.
Why do you think it happens to you?
Target. I'm just a target. I honestly, and like that's a part of where I wish that I could like get a hold of someone on Instagram, because like I realize that there's like certain things that I've posted that are against the rules or whatever, but I definitely feel like that there's like an overloaded amount of people who are just targeting me and reporting my stuff that isn't actually like, it shouldn't even be deleted. And so like I feel like that's where I have such a hard time. But like the worst part for me is just like the contacts and like the creatives and like
I know no one sees your DMs and stuff.
I mean, literally, like I met my boyfriend from Instagram, so it was like this is like a person who I may potentially spend the rest of my life with, who can maybe like I'll maybe marry him one day. And it was like I met him through my old account that was deleted, and the fact that I can potentially meet the love of my life on my Instagram and then it's like deleted, I'm like, you're taking away more than just a work opportunity.
I know. I can't, like, all the people that I used to have contact with that I want to work with, like, I can't get I can't get in touch with them because they don't follow my new page and they don't see my messages because I'm not verified. And so like,
or I can't remember. Like, I can't remember everybody.
Yeah, no, it's true. It's really frustrating.
So she's not the only one. Sex content creators across the industry have all faced censorship in the last 6 years, especially. This regulation of content made by sex workers results from social media policies that impose the harms they intended to prevent. Social media censorship and deplatformization of sex workers stems from the unpredictable outcomes of laws surrounding social media regulation. So, does Riley Reid even have a right to express herself on social media? Well, the Supreme Court is currently has evaluated a law that allows social media platforms to censor sex workers' speech as much as they choose, which will continue to threaten their safety and rights. So here's a preview of what's to come. We're going to be talking about Section 230 and Gonzalez v. Google and the outcome of that case, and the fact that I correctly predicted the outcome of that case. We're going to talk about the laws that led to the censorship of sex workers on social media and how the Supreme Court this decision affects social media regulation. So let's start with the state of the law today. If you don't know what Section 230 is, don't you worry, I'm going to explain it to you. Section 230 C1 and C2 of the Communications Decency Act of 1996, commonly referred to as Section 230, has been no stranger to the news in the last few years. The law made its way to the Supreme Court in February of 2023 through Gonzalez v. Google. In Gonzalez, a U.S. citizen was killed in the Paris terrorist attacks in 2015. Terrorist organization ISIS claimed responsibility for the attacks by issuing a YouTube video. Under the Anti-Terrorism Act, Gonzalez's family filed action against YouTube for aiding and abetting an act of terrorism by allowing ISIS to use their platforms. So Gonzalez v. Google raises the issue of whether interactive computer services targeted recommendations fall under the scope of liability provided by Section 230C1. Section 230C1 states, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Gonzalez would be the Supreme Court's first examination of the liability scope that Section 230 provides. So while the Supreme Court is evaluating the scope of Section 230C1, this presentation is actually going to examine the problems that stem from Section 230C2, which adds that no provider or user of an interactive computer service shall be held liable on account of any action taken voluntarily in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. So Section 230 as a whole really allows companies to moderate content or not moderate with no liability for the mass amounts of information on their sites. So this presentation examines the effect of Section 230 C2 on one group of content creators, commercial sex workers. So I want to take you back to the early 90s when the internet was just starting out. Courts and legislators were attempting to piece together solutions for the complex issues of new technologies. And without Section 230, we would have really relied on the two following conflicting cases that limited the internet's growth in its early days. In 1991, Cubby versus CompuServe examined the scope of liability for an internet service provider hosting defamatory material on its bulletin board website, which sounds a lot like a social media platform. The district court concluded that because CompuServe did not track the content posted and acted as a distributor of the content, not a publisher, it was not liable for the defamatory statements. The district court said that CompuServe has no more editorial control over such a publication than does a public library, a bookstore, or a newsstand. And so this decision really encouraged other internet providers to take a hands-off moderation approach so they wouldn't be liable for the content. But 4 years later, however, the New York Supreme Court faced a similar issue in Stratton Oakmont versus Prodigy Services. An unidentified user posted statements on Prodigy, another bulletin board website, stating that Stratton Oakmont committed fraud and criminal acts which they said were libelous. The court concluded that because Prodigy monitored the content and removed content that did not fit its community standards, it was a publisher of the information and liable for defamation claims. The New York Supreme Court differentiated Stratton from Cubby, stating that because Prodigy made decisions as to content, that constituted editorial control. The court concluded that editorial control led to liability. So these two cases resulted in a moderator's dilemma. So let's say you were starting off, you were making your own internet company, your own social media platform where users could post on your website. You would have to choose. Should we moderate content and keep users safe, but maybe be liable for something we might have missed and be liable for any content that's uploaded to our site? Or should we not moderate and take a really like hands-off moderation approach, allow all speech, but maybe users are going to be less likely to return to your platform because they're going to see disturbing, false, or libelous content. And so the solution became the Telecommunications Act of 1996, which included Section 230, allowing internet service providers to take down content or leave content up without liability. President Bill Clinton at the time said that the act was to provide consumers greater choices, remove unnecessary regulation, and open the way for freer markets. So you might wonder why we call Section 230 Section 230 instead of the Telecommunications Act of 1996. It gets its name because the rest of the Telecommunications Act was struck down after a decision in Reno versus ACLU. Section 231, which we don't hear about anymore, Section 231 made it a crime for anyone to engage in online speech that is indecent or patently offensive if the speech could be viewed by a minor. In Reno versus ACLU, the ACLU challenged Section 231, saying that its broad application infringed on the protected speech between consenting adults. The court agreed, saying that the act threatened to torch a large segment of the internet community and unconstitutionally restricted free speech. Because of this, the rest of the act was struck down, but Section 230 remained. But Reno versus ACLU was not the last attempt to torch a large segment of the internet community by restricting sexual speech. Sesta were a pair of legislative acts passed under the Trump administration, amending Section 230E5 to prevent online sex trafficking. The laws carved out an exception to Section 230, making social media platforms liable for sex trafficking content. Seems like a positive movement. It was a positive intention to remove content that was involving sex trafficking. With this positive intention, however, Sesta ended up pushing sex workers and trafficking victims into more dangerous and exploitive situations. According to the Decriminalize Sex Work campaign, Sesta endangers survivors and sex workers, impedes law enforcement's efforts to find victims and prosecute traffickers, and censors free speech. The restriction and removal of sex workers on social media heightens already existing challenges law enforcement faces in gathering tips and evidence. Additionally, when sweeping algorithms are applied to social media companies to comply with overly broad legislation, speech is chilled, and so too is the activism it drives. So, how were social media platforms actually handling content made by sex workers online during this time? Well, Meta introduced a policy 6 months after Sesta, and the policy states that Meta allows for the discussion of sex workers' rights and advocacy, but does not allow content that facilitates, encourages, or coordinates commercial sex work. Now, this seems pretty balanced, a balanced policy, but the enforcement of this policy was not as balanced. In 2019, Instagram announced it will be cracking down on inappropriate content, restricting the distribution of this content on Explore pages. And TikTok followed this same approach, saying that they were going to limit distribution by making content ineligible for recommendation into anyone's For You feed. So instead of removing the speech, these social media platforms restricted the distribution of speech, which just really leads to the same issues for sex workers. And as complaints surfaced, Instagram tweeted, "We do not target sex workers. We want to assure that to our community that this isn't true and nothing will change about the way we enforce our policies. But the data and enforcement shows otherwise. With this example, a creator was censored for simply using the words sex worker. And you all know from my experience, I've talked about this so much on my podcast. When I was talking about these issues, I was being censored on TikTok and Instagram. And I'm sure that any of my fellow sex content creators have experienced the same thing. And social media enforcement skyrocketed around this time. It wasn't just me, and it wasn't just our little group of the people I know. Appeals were higher, and content was later restored with content related to adult nudity and sexual activity. Appeals were higher, and content was later restored at a higher number in 2019 to 2020, meaning that more content that did not violate community guidelines was wrongfully removed and later restored. And this number is growing again in Meta's most recent report after a shortage of moderators in the 2020 pandemic. So, this chain of events really exposed the problem with editing the language of Section 230. Creating liability leads the platforms to remove more content to avoid litigation, further suppressing speech. But you might ask yourself, does anyone even have a First Amendment right on the internet? Well, it's not clearly defined yet. And here's ACLU attorney Mohammed Tazar on social media and the First Amendment explaining the complexity of this question.
Or Facebook is the one that's doing the banning or doing the, making you feel bad online. You don't actually have a First Amendment right as against them. So that opens up a real problem, because what if it is in fact the companies that are doing it? And if they ban you from their platform, is your First Amendment right violated? And the answer is no, but maybe the answer to that should be yes. And or if it's not the First Amendment doing that, maybe it should be some other laws or some other rules. And that, I think, is what a lot of people are trying to figure out.
Okay, so that explains part of the question. Free speech is a right we get from the government, not from a private company. But what about this idea of social media as a public square?
I actually don't quite like the framing of the public square. The public square is meant to suggest as a place where people can come together, talk, and discuss things freely without fear of censorship or violence or anything like that. And our great hope for the internet was that it was going to be this like wonderful democratizing public square where people can talk and discuss things. Anybody has a platform, they can do whatever they want. But that's not actually how it all played out. I mean, we don't have much of a public square. We have something more like a private bar, where imagine you can get in, but sometimes you got to pay a cover charge. And once you get in, you can barely see other people, and you're only mostly talking to people that you like. And that actually is, I think, the much more proper analogy for what we have here. The companies that control most of the ways in which we talk to each other online make it so that we don't actually have a robust, free public debate. They're mediating the conversation as a way for them to monetize the conversations that we have. So I don't actually think we have a public square. I think we have something totally different. And I think we got to start acting like we have that.
So, without even trying to answer that question today, it would require a whole another capstone. Even if we did have a First Amendment right on the internet, let's say that applies to social media. Would it go even further to protect sex workers' speech? Well, obscenity is unprotected under the First Amendment, but courts have really struggled to identify what is obscene and what is pornography. The US first adopted a test from a British case in Regina v. Hicklin in 1868. The Hicklin rule provided the following test for obscenity: whether the tendency of the matter is to deprave and corrupt those whose minds are open to such immoral influences and into whose hands a publication of this sort may fall. Many years later, the Supreme Court first analyzed obscenity in Roth versus US and determined the test for obscenity to be whether, to the average person, applying contemporary community standards, the dominant theme of the material as a whole appeals to prurient interest. The court then approached obscenity again in Memoirs versus Massachusetts and articulated a new 3-part test, adding that the content must have a redeeming social value. Now, Miller versus California is the leading test for obscenity cases in which they kept aspects like contemporary community standards and prurient interest, but added that it lacks serious literary, artistic, political, or scientific value. Since Miller was decided in 1973, the question of average contemporary community standards has been left to the juries. So here we're going to go back to Riley Reid. Here is Riley Reid talking to Eric Weinstein about the concerns with contemporary community standards as a test for obscenity.
So not totally lacking, it just has to be fairly lacking. That is terrifying in the age of the internet, because what is a contemporary community standard when we have one giant community? If you make porn in the San Fernando Valley, let's say, where its traditional headquarters has been, what if it gets viewed in Ogden, Utah? How do you know you're not violating somebody else's community standards? Are you worried about this at all?
Oh, I'm definitely. I mean, to me, it's very extreme, because what one perspective is to one person is totally different to another. Your life experiences, I mean, are going to be completely different. Your even like, religion has a huge play in all of these types of things, and I think that a lot of people just have totally different ideas on what is okay and not okay. And I think a lot of it is even just from lack of experience or perspective or communication with different people. So I think that some people even like many even of my own friends have totally different views on pornography and actors and actresses in the adult entertainment industry. And once they meet them, they're like, wow, I didn't even think that you guys would even, be this type of person. I've had people who like speak to me directly where they're like, I didn't like you until I listened to a podcast where I was like, oh, she's like a real human being. So I think that in general, it's really daunting and terrifying, the fact that if I want to do some really intense hardcore scene, that to maybe the general public will think it's, regular hot porno, but then there might be, 5% of the population who's like, oh my God, what did she just do?
Well, and that's just it. There's no way that you can control where your
No.
material will be consumed. So having a pre-internet, like almost 50 years old, decision govern in part who can be brought up on federal charges. My understanding was that Stagliano about 10 years ago was brought up and was possibly facing 3 decades in prison for making pornography.
Yeah.
So, as you just heard, leaving these questions to the juries leads to inconsistencies depending on geographic area, religious or political background, upbringing, and so many other factors. There is no one contemporary community standard. So, this concern was addressed in Ashcroft versus ACLU in 2002. Congress attempted to address the concern of exposing children to indecent material by enacting the Child Online Protection Act, or COPA. It's one of two COPAs, COPA with one P. Internet providers and civil liberties groups alleged that COPA violated the First Amendment because relying on community standards to identify what material is harmful to minors rendered the statute overly broad, and the majority determined that this did not violate the First Amendment. In an 8-1 decision, the concurring justices in Ashcroft questioned the legitimacy of using Miller as the test. Justice Breyer, in his concurrence, stated to read the statute as adopting the community standards of every locality in the United States would provide the most Puritan of communities with a heckler's veto affecting the rest of the nation. Justice O'Connor, in her concurrence, stated, adoption of a national standard is necessary, in my view, for any reasonable regulation of internet obscenity. After the court heard Ashcroft a second time, the court discussed the Miller test with more precision and reaffirmed the preliminary injunction of COPA on the grounds that the statute was not narrowly tailored to serve a compelling state interest. With this intention to protect children from indecent material, Broad legislation often sweeps up content made for consenting adults and infringes on adults' First Amendment rights. This was not the first time this happened, though. Sable versus FCC was another case in 1989, which attempted to balance the child safety and adult expression. The Supreme Court decided that while a government has a legitimate interest in protecting children from dial-a-porn messages on the telephone machine, the Communications Act was not narrowly drawn to achieve that purpose and infringed on the First Amendment rights of consenting adults. So the community standards have really changed since Miller in 1973. If someone were to face 20 years in prison for obscenity, the community standards are going to change over those 20 years. And these inconsistencies in community standards have been reflected in the social media platforms, sexual content, and adult content community guidelines. So, out of the 8 major social media platforms, only 2 allow adult nudity and sexual activity on their platforms with 18 plus warnings, Twitter and Reddit. But these differentiations do not encompass the complexity of each platform's policies. Amazon lists particular moves and positions and facial expressions that are sexually suggestive and not allowed on the platform, saying people in poses emulating a sexual position or alluding to the sexual activity, whether clothed or unclothed. That's one of Amazon's not allowed ads. And TikTok, as you know, strictly enforces sexual content, often by removing content that just includes the word sex. Google, on the other hand, specifies different levels of strongly restricted and moderately restricted categories. And Meta, I think, is the most detailed, drawing lines between sexual solicitation and sexual speech. But sometimes, not even posting at all can lead to removal, as seen in the 2021 purge of sex content creators online. And if you are listening to the podcast version of this, I have a tweet from Adam22 up on my screen saying that Lena, the plug, and Riley Reed's Instagrams were deleted. My girl literally hasn't posted in 3 months. What the fuck, Instagram? And this is just one example of many. And they have their content and their whole Instagrams deleted without much explanation, just stating that we removed your your thing because you violated our community guidelines too many times, but won't say exactly what we violated. So, could the Gonzalez v. Google case affect sex work, and could it provide a solution to this issue? So, in this presentation, I talked about the possible outcomes of Gonzalez. I said that they could strike Section 230 entirely. They could strike down just Section 230C1. They could find online platforms liable for targeted recommendations under Section 230C1. Or they could leave Section 230 as is, not answer the question, and leave it for Congress to amend, which is what they did. They decided that, you know what, we're not really gonna decide this. We're not gonna talk about it. We're not even gonna give you more than 3 pages of a decision. What they said, they really defer to their ruling in Twitter versus Tamna, which asks the question of whether Twitter or a social media platform can aid or abet an act of terrorism by allowing a terrorist organization to use their platform to promote their terrorist organization. So they really defer. They wrote an opinion in Twitter and said that they did not aid and abet under the Anti-Terrorism Act, under JASTA. They said Twitter does not aid and abet by allowing ISIS to use their platforms. And then they say in Gonzalez, we're going to vacate and remand and leave it, remand it to the Ninth Circuit, and they can use Twitter as the basis of this, of a remand. So they really don't answer this question, which was kind of disappointing, very expected, but I wish we had something to read and talk about today. So in my presentation, I talked about, it's difficult to predict the outcome, even though I knew what was going to happen. I'm so wise. Um, the court did demonstrate a lot of skepticism and confusion in the hearings. They said so many times, I'm a little confused. And if you're listening to this, I have on the screen a script of the hearings where Justice Kagan says, we don't really know about these things. These are not the 9 greatest experts on the internet. And then there's laughter in the court. That was my favorite part. But at the bottom of the screen, it says, isn't this something for Congress to do, not the court? So they are going to kind of leave Section 230 for Congress to amend, which is unlikely to happen. Section 230, while there are so many flaws and so many unfavorable outcomes that stem from Section 230, it is quite a balanced law, and I don't know what could be written that would be better. But there probably is something that could be written that could be better, that still doesn't impose liabilities, like total liability, or doesn't shield complete liability for the platforms, but like imposes some liabilities and content that they should have some awareness of and should have some regulation of. So if Section 230 stays as is, which is going to, that allows social media companies to remove sex workers' content that does not violate terms of service without any repercussions. And if they remove the speech, it leads to many unfavorable outcomes. It restricts investigations. Law enforcement has a harder time finding evidence for, a claim, and it restricts their investigations. Sex workers need internet services to create safety nets and protocols to keep themselves safe. Restricting their speech becomes even more problematic, because if we are allowed to talk about these issues, it silences them and their rights. And it does not change the market. If we get rid of this content online, it's not like sex work just stops. And we have to be able to talk about sex trafficking and how to solve those issues without being censored on the internet. And there's a physical risk for sex workers. They use the internet to tell other sex workers about potentially dangerous clients or dangerous agents or whatever it is. They need these tools to be able to communicate about potential dangers. There was a really interesting study from Baylor University which estimated that a rollout of Craigslist erotic services decreased the female homicidal rate nationwide on average from 10 to 17% from 2002 to 2010, which was a very fascinating study, which is linked in the PowerPoint. So what should social media companies do? Because there is no one governing body on the internet. So that is why Section 230 is kind of like the major law for internet companies. But the internet is global. So there's no law that can really regulate all of social media. But it really is these issues really depend on the social media companies taking ownership of their content. So how can they kind of solve these issues? They can hire more humans. Now, I'm not saying only hire humans. Algorithms are great. AI is great, but it has to be a joint effort. Allowing humans to review the content that is maybe on the fence improves the user experience. There might be less effort, less errors. A con to this is it might cost more time and money than automated system, and you are risking a mental health damage to employees. Implementing wellness standards are great, and I have linked in here Google's new wellness standards for content moderators, which is really fascinating and really exciting that they're talking about this, the mental health harm of content moderators and trust and safety professionals. The second thing is to hire experts who are solely going to focus on adult nudity and sexual activity and sexuality policy and law as their sole focus. Hiring experts on this issue in particular is better, and it enhances user experience so that somebody who's reviewing this content is not split in they need to just have a specialization in sexuality law. A possible con to this is that sexuality law is like having one person determine the contemporary community standard can be very difficult. And that's a con to a lot of my suggestions. There is no one contemporary community standard that we can agree on here. The next thing is policy enforcement. Enforce those policies fairly, keep the appeals processes, communicate reasoning for takedown that's not automated, especially for bigger content creators in the sex industry. And just being able to communicate what the reasoning was for a takedown so that they know to not do it again. The next thing is partnerships with stakeholders. I think that these companies should, if they aren't already, and this is all my suggestions, a lot of these tech companies do already. This is for companies who might need some improvement. And these are very broad suggestions. They are very broad suggestions and they are very general. But partnerships with stakeholders. Social media companies need to partner up with the NGOs, sex advocacy groups, and the sex workers themselves so that there's more conversation around developing laws and the new drawbacks of new policies that they're going to implement so that they know how these things are really going to affect sex workers' speech. Making adjustments in the policies is the next one. Specify the nuances. Sex education is different from sex art, and it's different from sex work, and it's much different from sex trafficking. Sex work is not sex trafficking, and those things should not be talked about in the same conversation. They are two different things. And like defining obscenity, creating one community standard around adult nudity and sexual activity is very difficult. So that's a con to this. There might be differing views on how sex workers should be able to articulate their work or who they are. That's important to draw the lines between in the social media policies. It shows that the platform has made this concerted effort to differentiate between education and art and all of those things. The next thing is social media relationships with other platforms. Snapchat and TikTok need to be friends and need to talk about these things and try to come up with one solution or at least a more streamlined solution to this content, because all of the different moderation policies are really hard for sex workers to understand. Why can we not use the word sex on TikTok, but we can post full-on porn on Twitter? And again, it's hard for these social media companies to agree. They also serve different purposes. TikTok is really, they claim, is used by a lot of children. We'll implement 18 plus warnings for these things. That's how Twitter does it. So those are just some broad suggestions for tech companies, just things we should start talking about and thinking about to make these issues a little bit easier. So although requiring time and investment, devoting effort to this issue leads to healthier conversations around sex work, sexual health, and free speech, inevitably creating a healthier internet. And if you'd like to learn more, I have linked some things here and I'll link them in the podcast description below. And you can also read the paper through this Medium link. I will also link that below. And that is more of the legal writing paper. So there's more legal jargon in that one and more background on some of the findings I found. And you guys already know, you can listen to my podcast. I talked about my podcast in all these presentations, and you can email me if you want, if you're interested. I have my UCLA email in there, but you can email me if you want and talk about this and let me know your thoughts on this. And I said with that, I'll take your questions, but this is a one-way conversation on this podcast and on this YouTube. So I'll take your questions in the comments below or in my DMs. You are free to ask me questions or write me your thoughts. Let me know what you think. And I really thank you all for listening to this one. It was like, that was the capstone. That was it. And it was awesome. And I was so lucky to be able to speak about these issues. And I was so happy to talk about Riley Reid in an academic setting. It was so fun. Should we tag her? I want her to know that I was talking about her. Maybe we'll find a way. What if I had Riley Reid on the podcast? Okay, I'm not gonna freak out just yet. Anyways, thank you all for listening, Elevation Nation. Like I said, I have a plan. We'll see how it goes for season 6 of the Elevated Podcast. I'm stoked. We're going to talk more about tech policy and sexual health and self-development and where things are going right now. And I am just stoked you're on this journey with me. Thank you all for listening, and I hope you feel so elevated, and I will see you next time.